So these three gentlemen really probably need no introduction. I will give them a very brief introduction. I prefer brief introductions, and anyway, but when you have people like these gentlemen, one sentence, the more important you are in the industry, the one sentence introduction should tell everybody everything they need to know about you. So starting with the audience's left, we have David Kapos. Prior to becoming the Undersecretary of Commerce during the Obama administration and Director of the Patent Office, Dave was the top legal IP person for IBM, and either of those accomplishments are capstones for most people. And now Dave is practicing as a partner with Cravath in New York, and we appreciate you being here.
Great
Dave.
to see you.
Next is Scott Keefe. I'll give you a factoid about Scott that you probably don't know. Scott is many of you in the room probably do know, but Scott is a national security expert. He consults on national security matters. He is a former commissioner at the ITC and a current professor at GW Law School. Scott, thank you for being here.
It's a pleasure to be here. Thanks for
I should be
bringing us
addressing
together.
all of you as Your Honor. Your Honor, thank you for being here. Your Honor, thank you for being. And then certainly, Judge Michelle, Your Honor, it has been a privilege to get to know you over the years. And I tell everybody that without your support, none of these programs that we're doing would have gotten off the ground. I remember laying my idea out to you and you encouraging me, and like so many folks in the industry, you've been a great mentor and a wonderful friend to me and Renee alike. Judge Michelle is former chief judge of the Federal Circuit. He was also a staffer in the Senate for many years, working with Orrin Hatch on the Judiciary Committee. He was involved in several of the Gates, Watergate, Koreagate investigations when he was attorney at the DOJ. And Your Honor, it's a privilege to have you join us again here today.
Thank you, Eugene.
So the topic that we're going to try and talk about here today is the myths about standard essential patents and implementation. So before we go into, I've got a few of them teed up that we can talk about and kick around, but I'd like to just get your preliminary thoughts. Judge, maybe we'll start with you.
Well, I think that the courts have badly failed the patent system because it only functions effectively and fairly when there are reasonably well-balanced incentives on all sides. And the courts have destroyed the balance of incentives, not only because of the way eBay has been implemented, but with other doctrines as well, including damages law and obviousness law. So it's a serious breakdown, and it's discouraging to me as a former judge, but it needs to be acknowledged. And of course, this leaves the question of how to repair it. To the extent it's a result of Supreme Court rulings, difficult to repair, since the court seems to never want to revise anything it's done before in the patent arena, at least. And getting legislation passed or trying to do it through the patent office has huge problems to it. So we're kind of in a trap. And it was the responsibility of the courts to keep the system balanced, and they failed.
Okay, great. Thank you, Judge. Scott, your thoughts?
So just to build upon the discussion already, one of the things that really impresses me as a professional and as an academic is how wonderfully smart most people are. And I mean, that's great. That's a blessing. That's a wonderful thing for humanity, mostly. But it also is an opportunity for lots and lots and lots of boundary testing and uncertainty as people debate with each other their own views or their own realities on different things. So what do I mean by that? I mean that if we, as intellectuals, as academics or professionals, ask ourselves, like, what does something mean? It's just quite hard to have that conversation in any disciplined way without resorting to a whole lot of context. Even if you're a strict constructionist, originalist, textualist, you're looking at the surrounding text and the time. So I mention that because the act of engaging in more conversation can be, in so many settings, very helpful. But there are times when enough is enough. And if what you're looking for is something akin to finality, at least enough finality for individual market actors to choose to just let it be and move along, then the incentives have to line up for them to elect, to choose, to let it be and move it along. And if the incentives instead are just keep the conversation going, then you should not be surprised. The conversation will keep going. It was a real treat for me years ago to work with then Chief Judge Michel in the Federal Circuit's appellate mediation program. And there were a group of us. The chief brought together a whole group. I think we were originally 6 or 7 of us. We were mediating almost all of the patent appeals coming to the Federal Circuit. And we were talking to mediators at other courts and comparing rates of, let's call it, success. And one of the things you see when you look at big data sets of deal making, one of the things you see is not all deals get done. And that's because not all deals should get done. Think about it this way. You, as lawyers, write. You also advise, but you write. You write text, and you bill your clients for your text. It might be the case that you are, as lawyers, nothing more than this giant transaction cost in society extracting value from the goodness of the world when you write in your deal documents more than patent number and the number of dollars or cents or yen or pounds or euros. But it might be that you choose to write pages of text in your deal documents because your clients, for a very good reason, care deeply and powerfully about a whole lot of other things than just price. So we really have to then notice deals can get done or not get done for a whole lot of reasons other than price. And most deals in successful mediation sessions, in large data sets of successful mediation panels and systems, are in fact not getting done for good reason. People don't want them done. So that's just information.
Okay, great, thank you. Dave.
Yeah, well, good afternoon, Gene, and great to see a bunch of friends here and to be back here at IPWatchdog headquarters, and thanks for putting on another great program to talk about a topic that, as you've said already, Gene, needs to be discussed in a sober, I'll say, and mature fashion. So the first thought that comes to mind for me is I don't think it's one of the myths that we're going to explore already, but it's close to a number of them, which is the myth that SEP litigation is out of control. And so that of course is a premise that's at the root of a lot of what's going on. The planned and threatened regulation of SEPs in Europe, the creation of a new royalty rate setting tribunal in EU IPO, actions that over the years the DOJ has taken here in the US, statements made in Congress that have found themselves or found their way into the consciousness of members of Congress. statements that have found their way into the advocacy and actions of the FTC, and on and on and on. And it's a narrative that the SEB litigation is out of control. It's a narrative that feeds into some popular beliefs and leads to a premise that, or leads to a presumption, we got to do something. It's out of control. So I took a look at the actual data, kind of useful to do that once in a while, and winnowed down all litigation in the U.S. to SEP-related litigation, and then you have to winnow it down further from there to SEP-related litigation with which party is the plaintiff and which is the defendant. In other words, was the suit brought by the defendant on the basis of a declaratory judgment action, or was it brought by the plaintiff patent holder? And then also another facet, which is, was the suit actually based on SEPs, or despite the fact that the suit was about an SEP-regulated industry, was the suit actually not about SEPs? Because it turns out, if you look at these cases, a lot of them actually, while they're brought by parties over standards, they're not about SEPs. And so what the data wound up showing, you might not be surprised to hear given my wind-up here, is that SEP litigation is not out of control. It's anything but out of control. It's a tiny little fraction. In most years between 2000 and 2020 or so, when the data set petered out, you could count the number of SEP cases literally on one hand. In many years, you didn't even need any fingers at all because the answer was 0. And in the years when the numbers were comparatively big, like a dozen or more, what the data showed was there was one company behind the majority of the litigation, either as the plaintiff or the defendant, that company, Apple. Mm-hmm. So you find yourself in a sort of a self-fulfilling prophecy, right? The companies that want there to be a perception that SEP litigation is out of control are refusing to engage in the licensing marketplace and forcing litigation or bringing litigation themselves, and then they're complaining that SEP litigation is out of control. This is another version, right, of the boy after having, well, I won't go into the details, but claiming to need the sympathy of the court because of being an orphan, right? And it actually doesn't work that way. So I want to just get you off on a good foot here, Gene, by saying the myth that SEP litigation is out of control is indeed a myth, and it's a falsehood.
Yeah. I don't think it's out of control. I think the perception, some would like it, us to perceive it as being out of control, but to the extent that it's out of control for them, it's a function of their choices. And it's interesting. I find it interesting because, sure, I mean, some patents are going to be invalid. These portfolios are gigantic, and they won't take a license. And there's no patents in these portfolios that are worth paying for, and none of them, all of them have to be challenged. And it's I don't know. I find it interesting. Let's go through some of these myths and talk about them. The one that came up recently at the USPTO listening session, I almost couldn't believe it, was said, is that innovators do not rely on licensing royalty to justify their continued research and development relating to standards. They just innovate out of necessity to remain on the cutting edge of innovation. And when that was said, I thought to myself, well, somebody who engages in R&D as a business choice that can't then monetize that R&D, they're going to go out of business. They're going to go bankrupt. I mean, and Apple's the one who said that. And they say it very confidently and very proudly. And I don't see Apple giving away an awful lot of iPhones for free. I mean, maybe I missed the giveaway. Maybe we'll see with Black Friday, they'll just start giving the stuff away. But when innovators who are innovating as their business don't have recourse to monetize that, the business will cease to exist. And I don't understand why that's not self-evident. And I was shocked that that was said. And but I'm hearing that from more and more people. Dave, you want to you can go in reverse order.
Sure.
now.
So I think definitely it's one of those I can't believe I'm hearing this moments, right? But Gene, to put a bit of a finer point on it, you know, and I work mostly in the real world, right? New York City, where people are all about commercial economic outcomes.
You mean as opposed to DC?
Yeah, I didn't want to, you know, draw a fine distinction there. But so if you're investing significant funds in innovation as a for-profit company, you don't stay in business long, or you don't stay in leadership long unless you can explain that to your management, your board, and your shareholders. And there are two ways, and there really are only two ways, that investment in innovation gets monetized such that an innovator can stay in business. One of those ways is to have an advantage in the marketplace through something other than an intellectual property position, network effects, first mover advantage, those kinds of things. And there are companies that, walled garden, right, that have that kind of advantage, and they do quite well, and that's perfectly fine. The other way, right, is to have some intellectual property position that enables you to, and then there's like a fork in the second part of the analysis, which is an intellectual property position that either enables you to charge a premium for your product in the marketplace, right, or that enables you to collect a royalty. It really is just that simple. And so on this second path, we really have made a choice when we agree to put our innovation into a standard. We've chosen not the path of having the ability to exclude others to charge a higher price for your product, but we've chosen the path of collecting royalties. So we've selected among essentially three choices, you know, two major forks and then one minor fork. We've selected a path of gaining remuneration by licensing. Unless that can be explained to the board of directors and shareholders, the company simply will go off in a different direction, right? And it won't take long, and senior management will be dismissed, and new management will be brought in. That's just the way it works. So at the end of the day, the party that goes down the road of monetizing research and development through licensing, right, is entirely dependent on the operation and the efficacy and the relative efficiency of a real licensing marketplace. If that breaks down, the party's business model breaks down, and again, they have to go and do something else for a living. Now, the last thing I'll say, because I think I've now already, Gene, helped you dismiss the myth by pointing out that there isn't any business model in the SEP area other than the licensing business model. But the one other thing that needs to be said to put a context around this is to step back and ask about the almost crazy leap of faith that the innovators around standards have to make, right? And it is as follows, right? They're investing billions of dollars up front, years ahead of a standard being created, on the hope that their intellectual property will be chosen for the standard, and on the hope that the standard will succeed, and on the hope that once it does, they'll be able to obtain some economic remuneration. I mean, it's like having to win the lottery almost, right? And it's an incredible leap of faith. I have tremendous respect for companies that undertake that business model, because it is so hard to get through that triple-part gauntlet and actually get compensated for your R&D that did get accepted into the standard, that did wind up being successful. So when you put the risk that innovators are taking into that context, you find yourself feeling like, we really should be holding these companies up as champions and richly rewarding them and not only respecting but heralding their business models and the selflessness that they're undertaking in putting their innovation into standards, instead of, as we do so often, holding them up for ridicule and criticism for wanting to be compensated, after all, decades later for the innovations that they created in the hope that they'd be standardized, in the hope that the standard would be successful, in the hope that they'd actually get paid.
There's a certain Popeye-esque kind of, do you remember when Wimpy would go and he would order, "I'll gladly pay you Tuesday for a hamburger today." Right? Well, that's fine if between now and Tuesday there's not like a depression or a recession that deflates the currency and that sort of thing, right? When you create these things and then you have to fight for a decade or more, there's also just a very real aspect of inflation. Where do I pay you? Do I pay you on $2013? What would have been fair back then? Or do I pay you what's fair now in 2023, exaggeratedly inflated over the last several years, and based on the rate that you would get today, and based on the rate having realized that you couldn't have done this at arm's length, that you had to chase me. Scott, I see you shaking your head. I mean, we're so shockingly in agreement, right?
I think so. And just to go back to some of the prior thoughts, so, why does context matter? Context matters because we can debate anything. Let's get down in a corner of an argument and talk about how patents are not like real property, land, because they're intangible. Patents have all these words, legalese. It's confusing. Our patent office has to re-examine our patents and post-grant review our patents, and a lot of them get fixed, corrected, thrown out. You can go pretty far to a corner of a debate and find a lot to debate about. So I like to encourage, when I'm mediating, parties to think about their alternatives. When I'm in an academic discussion, I like to think about alternatives. I like to see what I can learn. Is it true that human beings and markets crumble, can't cope with imperfection? And how do legal systems act when people crumble around those things? Well, here's some thoughts. Is the market for ad traffic a market for a tangible baseballs or land? No. I mean, baseballs you can touch, land you can touch. Ads and ad traffic are pretty ephemeral. They're an intangible asset. The ad market is a market that is notoriously fraught with error. People get ads for stuff that they probably are going to buy once every 20 years right after they've clicked to buy it, which is crazy. And when you ask for the last 100 years CEOs what they think about their advertising budgets, they'll all tell you always there are lots of funny quips about ads. CEOs will often say they hate spending money on their ads. They know that a huge percentage of their marketing budget is really wasted. They just don't know which half, or which 2/3, or which 1/3. Okay, but that means that's a market that's absolutely, totally fraught with error and imperfection and intangibility and frivolity. So is it the case that you can walk into Google and take all of its money because it's all based on that ad flow? I'm pretty sure they would tell you, that's my stuff. Get off, get away. They'd get an injunction. They'd get beaucoup damages if they sought civil remedies. So sure, we have markets and we still enforce powerful remedies, including equitable remedies. Think about stock markets right after the crash. You pick your worst crash. Was there ever the view that the right thing in our society to do was to say, those are mere entitlements, they're not property rights and land, therefore I'll take all of your stock? Society never made that choice, not a once. Was President Biden really ill-advised when he told students, don't repay in your debt market, I'm going to use my emergency powers? Maybe President Biden should have just said, don't repay in your debt market. It's an intangible asset. Some of those debt instruments have spelling mistakes and all sorts of other errors. Some of them might even be thrown out by the bank examiners who, according to today's Wall Street Journal, are a little too often doing things maybe no organization should condone, using government money to sexually assault each other. But maybe those perfect bank examiners, maybe. This is absurd. We enforce debt instruments, equity instruments, trade secrets, lots of intangible assets with powerful civil remedies for money and even injunctions, despite how error-prone they are, despite how numerous they are, despite how intangible they are, despite how free and open or common carrier-like the commitments have been, we still say to people, if it's not yours, you don't get to have it, and you don't get to have it at the price you pick. Those are basic ideas, and the context, the comparisons, help inform our thinking.
Yeah, or it should help inform our thinking, right? Judge, your perspective, I don't want to pigeonhole you. I mean, you've been around and seen an awful lot. So I'll just leave it open for you, but I want to come back to you with a specific question.
Okay, well, let me revert to the perspective of judges and courts, and because they're the implementers of law, it's also the perspective of law, and that is to try to replicate a reasonably accurate and complete version of truth by evaluating evidence. That's the core MO of judicial decision-making. In our country right now, patent policy is not being made in that fashion. It's being made by myths, narratives, and sometimes counter-narratives and counter-counter-narratives. The problem with narratives is that they aren't the truth covering the context and all the relevant facts, and they aren't based on evidence. They're self-serving misstatements of the reality. So, for example, when Apple said to the patent office, as Gene quoted, inventors don't rely on licensing income, they invent anyway for other reasons. It's possible that that might be true of a very few particular companies. But in the United States today, we have 35,000 sizable commercial corporations and hundreds of thousands of slightly smaller commercial corporations. So if a handful, 20, a couple dozen, maybe don't depend on licensing income and do meaningful innovation, okay, fine. But that's a speck of the whole truth, because huge numbers of people do depend on licensing income to innovate, particularly if by innovate you mean in a major way so-called disruptive new technologies. So I have a problem with narratives or myths because they're inherently actually a sophisticated lie that's told to serve a certain purpose, in the case of the example you give, to be defensive of Apple's behaviors. but it's not a good basis for making decisions that constitute patent policy in our country. And it's not just that these myths or distorted narratives influence Congress, they also influence executive branch officials at various levels, from the White House down to the newest examiner. And they also introduce courts, because courts live in the culture. They're not immune from being biased and subliminally influenced by myths and narratives, no matter how misleading. So we have a real problem in this country if we are going to make decisions in any public authority at any level based on narratives and myths, as opposed to accurate depictions based on, David says data, I say evidence. We're talking about essentially the same thing. In other words, real facts, not hypothesized facts. So we have to get away from myths and narratives if we're going to have any kind of chance of having a better functioning system. And then the last thing I'll say, again, going back to the perspective of courts, is courts have a conceit, I say, because they're smart people. They got nominated by a president. They got confirmed by some senate or other. They have a lot of power. They have a prestigious job, a very interesting job. I loved every day of the 22 years. But they quickly overestimate their own wisdom as compared with other people, particularly in the private sector. So if we talk about fair damages, FRAND damages, reasonable compensation, the courts have this idea that they're the best ones to assess what's reasonable. I say they're the worst ones to assess what's reasonable. The best ones are the business leaders of the contending corporations, because they know their own capabilities better than anybody. They know their vulnerabilities. They know their projections of what's going to happen in the market with pricing and competition and new technologies and alternatives and all the other factors that business leaders weigh every single day. So I say the less the courts have to decide, the better, because the better deciders are the private actors.
Yeah, I think that's true. When I first started off litigating, I know a lot of judges would encourage us to settle. And the way that they would do it would be to say is neither one of you are going to like my decision. So maybe you ought to pick which terms matter to each of you most and see if you can sort that. And the one judge, when I was very young, I heard him say, he said, because I have no idea what's important to you. I could think that this matters most, and I could think that that's just, and I can think that this matters most for you, and that that's just, and maybe I've got it exactly backwards. So go and figure this out on your own. And I fundamentally think, at least in the U.S., that we have abandoned that approach to the law and force innovators to have to go to court.
That's exactly right. I mean, the reality is a patent anymore is a ticket to be able to file a lawsuit and spend 5 to 10 years to get a final judgment and maybe a payout at the cost of many millions of dollars. This is not an asset. That's a cost that's being incurred. So it reverts back to the problem that the Supreme Court, I think unintentionally, unwittingly, ruined the leverage between parties by making injunctions almost impossible to get, the way that eBay gradually got implemented by lower levels of adjudicators. So you take away the leverage and the bargaining doesn't happen, so then you get more litigation, more inefficiency, more expense, worse results. So one part of rebalancing or reviving the system as a mostly voluntary system, worked out by private actors, not judges or legislators or executive branch officials, is to restore the leverage by reforming injunction law.
Yeah.
Well, sorry, go ahead.
Go ahead, Scott.
Yes,
No,
well,
I'm
very
sorry.
briefly, I was going to
Sure.
say it's an example of the old adage, right? Good fences make good neighbors. We no longer have any fences.
Right.
And a related way to think about that is just to build on what both of you have pointed out, and Gene, you have pointed out as well. Think about a world in which Company A That's a team of human beings. They sit down, they talk together, they figure out what is in their best interest. Company B, they're another team. They sit down and they talk together and they figure out what is in their best interest. Think about a world in which they have each the incentive and capacity to develop for themselves the authentic, autonomous, different set of hopes, dreams, aspirations, vulnerabilities. Do we want a world in which they get to have those and keep those to themselves? If so, we want to allow them, in fact, we want to strongly encourage them to negotiate directly with each other and express those negotiations in whatever terms they like. It could be units of money, it could be units of service, it could be any number of things. I'll give you access to my investors, I'll give you access to my customers, I'll give you access to my treasure trove of technology or money. That's a world in which they don't have to decide immediately up front their hopes, their dreams, and they don't have to communicate those. All they have to communicate is what works for their trading partner. Think about an alternative world where you or we have to figure out the right value for it. Well, the only way to figure out the right value for any it is for the evaluator external to get all up in the business of party A, its hopes and dreams, its secret worries, and so forth, and party B's. And that means we have created a world in which all of that very involved, very invasive transfer of information can only happen in front of a court or an agency that will set the right Fran price or the right price if it's something other than Fran. That's a system where then no privacy, no real secrecy, and large established players who are quite adept at pouring lobbying dollars down K Street will get rule sets and administrative systems well adapted to their goals, and everyone else is being served up for lunch, except when they're also for dinner. So that just seems like a very scary system that at its best requires grand wizards inside government to be getting it right every time and never to be transacting in the political economy space. But we know that world doesn't exist, not even close.
Well, the thing that's frustrating is pretty much every other area of law that works where you have the need for arm's length negotiation and both parties really need each other. There's certain rules. There's specific and well-defined rules that everybody can understand. Like the one that, as you guys were just talking, I was thinking about back in the day, I was a co-owner of an independent record label, right? So I know that industry a bit. And if you want to make a cover of the latest, greatest song, anybody in the world could do that. There's a mechanical license. It's in the statute. This is what you have to pay. And guess what happens if you don't do that? There's punishment. You're going to wind up when somebody comes knocking because you didn't pay this is what we have an arm's length negotiation. It's really just send the check. It's an accounting process. Well, if you don't buy into that accounting process, now it's an infringement. And now when they're coming after you, they're going to shut you down and the damages are going to be much higher. But it's certain. It works. And in this area, we don't have the incentive for some, and I have to stress that that's for some, right? Just a couple days ago when we were leading into this, we were talking, Renee asked me, It's like, well, where does Verizon fit into all this? Companies like Verizon. I'm like, well, they're really an implementer. They innovate, in certain things, and they have patents. But in the 5G area, they use the technologies of the Qualcomms and the Ericssons and the Nokias and the InterDigitals and all those other companies. And then it struck me as like, I know at least at one point in time, and I don't know about like right now, but Verizon must have had a very good relationship with Ericsson, because when they were going and doing 5G, they have Ericsson and Verizon in videos on Ericsson's website talking about, these centers at these football games and these mobile 5G hotspots and networks that enable all kinds of. So there must have been a partnership at some point, and they work together. But if you don't have both parties seeing the value, and one party can just run away and hide, it makes up the whole system.
Dave correctly points out that the boundaries of what's protected by a patent have been made so unclear by foolish court decisions. But it's not just the boundaries, it's whether the patent is really a patent, or whether it's invalid for ineligibility, or it's invalid for obviousness. And once again, the courts, I think largely unintentionally, but the impact and effect was the same, have so muddied the law that uncertainty is pervasive. So the more uncertainty there is, the less rational business people and lawyers and others who advise them can navigate the world. We've made it blind to them, and it's very counterproductive. So I'm for maximum certainty, and that's what we have to get back to.
Absolutely. David, looked like you wanted to say something there.
I was just nodding in agreement.
Yeah.
And there are different kinds of uncertainty, right? One kind of uncertainty is, for the patent geeks in the audience, we know the famous cases of the single student thesis on the shelf at Reed College Library or the University of Freiburg Library, and that's uncertainty, but it is categorically different than what will a political actor do in a given political season, depending on how many billions of dollars have poured down K Street in anticipation of the next election. That's a different form of uncertainty. And in a weird way, is the student thesis there? That may be expensive. It is. You have to put lawyers on airplanes. They have to go to the University of Freiburg. They have to depose the librarian and ask, when did this thesis get put on a shelf? When did it get cataloged? That's a non-trivial cost, but it's tiny compared to encouraging our society to simply pour lobbying dollars over a discretionary decision around a nebulous concept like what a government actor tells you is FRAND, or a government actor tells you is close enough to a computer that it's no longer patentable under 101, or golly gee, you really want to be in the position of saying to a government actor, it wouldn't have been obvious to her, she wouldn't have thought of it, because she's going to tell you she's pretty smart, that's how she got in power, and you're pretty dumb if you challenge it.
Yeah. Well, let's move on to another one of these myths that I wanted to get to, and I'm going to kind of weave two of them together here. The one that always strikes me is just, I just don't get how anybody could say this, but innovation becomes more valuable once it has been declared to be standard essential. And then when you put that together with when patented technology is adopted as a standard, the patent owner can gain enormous windfall because they can hold up implementers. Now, it strikes me that the reason that technology gets adopted into a standard is not to give the innovator a windfall. It's because the whole purpose of these standards bodies is you have a whole bunch of nerds and geeks like us deciding this is really cool, this is the platform that everybody needs to build on, and if we set this, then really wonderful things are going to happen, and the industry can go in whatever direction it wants to go from this floor. That is not a windfall. That is a recognition that you have come up with something that's so important that the geeks, our friends, the geeks, people we went to engineering school with, and have come up with for everybody to benefit from, and it's not vice versa. And I don't get how people can say that. Dave, thoughts on where that comes from?
Yeah, so the view that the patent suddenly becomes anointed is actually, turns out, opposite from the truth. I didn't finish a point that I was sort of teasing at before, but it turns out that in the litigation that occurs around standards, parties, if they can, assert not their SEPs, but their non-SEPs, because they have a lot less baggage. When I advise clients on this topic, I will actively tell them the last thing you want is to get your patent designated as an SEP. It's almost got to be dedicated to the public once that happens. You're much better off with patents that are not essential to a standard. So it turns out the opposite of what is being asserted is closer to the truth. It's not like a ticket to stardom for a patent that gets designated as an SEP. It's almost a required dedication to the public for such a patent. So you got to turn the whole notion around. And of course, your statement before, Gene, is absolutely correct. The standards, which again, despite those who decry them as being broken, the SDO, Standard Development Organizations, work surprisingly well and historically have worked amazingly well at winnowing the best technology, at not getting caught up in politics, at not trying to play lawyer, and instead finding the technology that works the best, designated that as the standard, and trusting the system beyond that, and the system deserves to be trusted. It has worked extraordinarily well for us. And so, the notion that the patent gets anointed is, again, opposite. The patent is just a reflection of the best technology that was chosen because it was the best technology. So I would say it actually deserves, to the extent it gets anointed, that's something it deserves to have happen as a result of surviving the standard setting process.
Yeah.
Anyway,
Judge?
where is there evidence of holdup being a pattern? All the empirical research seems to me to be extremely lopsided, that it's a theoretical possibility that some academics postulated 10 years ago, but the evidence of it actually happening more than once in a blue moon is nil. And as to windfall, how are you going to get a windfall based on a holdup when you can't get an injunction? So we go right back to the beginning of the circle. There's no incentive. So there's not going to be a holdup. There's not going to be a windfall. There might not be anything, at least not for 5 to 10 years. And that's too little too late.
Yeah, the point about, coming back to data or statistics, the point about the stack deserves to be made finally. I'm aware of at least 3 studies that are very, very credible and that go back at least 20 years and have found that the stack is in the 3-ish% range. Maybe it's 3.5, maybe it's 3.1, but it's not 20, it's not 10, it's nominal, and it's stayed that way for a couple of decades now, an entire generation within a very tight boundary.
Well, let me
along
okay.
with, if I may, consistent, falling like a rock, quality adjusted prices with consistent entry into the market. And those are evidence of powerful disciplining incentives on the so-called owners. That means, if they were shaking down customers or competitors, you wouldn't be seeing competitors choosing to enter, and you wouldn't see prices falling like a rock. Those things don't happen if people are pushing others out.
So this to me, Scott, is a super important point. Take a little bit further. Remember was it a PwC or one of those studies that occurred a number of years ago that tracked the consumer surplus, net aggregate global consumer surplus created by the smartphone industry? And it's astronomical, many trillions of dollars. It's like the greatest innovation in business models and technical business models ever.
And I mean, just ask yourselves, $1 billion sounds like a lot of money. I mean, they don't pay us that much in academia. I get it, but $1 billion, a few billion dollars, that's less than what we spend as a society on Halloween every year, just for the fun of it. When's the last time you saw anywhere in the US patent system sustained royalty rates, dollar awards, and jury verdicts affirmed up through the court system that approach anything resembling $1 billion? You can count maybe on one hand. So we're reorganizing our entire public policy discussion around less than Halloween, a frivolity. There's just, and I'm not against Halloween. I think it's lovely, but that's not a magnitude of data that ought to be driving our thinking in that direction. It's a version of the let me tell you all about how your stuff absolutely is not worth anything, but my stuff is worth just like deliciously lots of money. And by the way, I don't even mean that your stuff isn't worth anything while I reach into your pocket and take it. So yeah, I mean, it's easy for me to tell you that your stuff ain't worth nothing, and it's easy for me to tell you that my stuff is, especially if it distracts you enough that I can reach into your pocket and take it.
And Gene, you know, you ask about how can people say things like this that are so obviously suspect or flat out false? Well, the answer is simple. They're being paid, well paid, to say stuff that isn't true because it serves some company's interest. It's that simple.
It's that simple, but you know, like if I would have said this type of stuff in front of the judges when I first started practicing, it's sanctionable. It is, these things are sanctionable. You know, and anybody who's been in front of a district court judge, a federal district court judge, some of the most highly competent litigators across the country become district court judges, you would have your head handed to you.
Well, here are some Nobel Prize winning, I hope, non-sanctionable realities. Options are always of positive value. I mean, I hope that's an uncontroversial point at this point. But we know that if the rules of the game are the last to the table through the greatest legal process, not private ordering process, pays the lowest price, then I think everyone else's options went away, or everyone else was a fool. The patentee was a fool. She I don't know why she thought she'd be able to have the autonomy to say no. Well, I mean, I think if we charge the lowest price for the last to show up after the lawsuit and the agency investigation, I think her no meant nothing. I don't think she had the autonomy to say yes. And I don't think she had the autonomy or the audacity to say, you know, yes, but only if, and then a 30 or 60 page deal document, which, by the way, again, says a whole lot more than some dollar amount. So, you know, we're sophisticated human beings. She ought to be allowed to speak in 30 pages and see whether other parties speak with her and choose to speak with her in agreement. They have the option to say yes to each other, the option to say no to each other, and the option to have highly variegated versions of those deal documents. These are sophisticated people. And is every one of those an identical deal document? No. But that slight variation doesn't count as vitiating the FRAND commitments. It's within the bounds of the FRAND commitments. But if the rule is last later gets lowest price, I think you've made all of those other people and all of those other autonomous decision-making processes to choose to strike a deal, to choose not to strike a deal, all of that autonomy ripped to shreds.
Yeah.
Why are we doing such violence to that?
Yeah.
Well,
So-
and
so-
it also speaks to the holdout point, right? It's obviously going to encourage more and more holdout.
Yeah. So if anybody has a question, Renee has the wireless microphone. And while we're getting Renee in position with the microphone, what I'll say is, unfortunately, Kent Baker can't make it, but he had an issue that won't allow him to be here with us. But one of the things that he would have said during his panel that I'll bring up with is apropos right now is he said, I can't take a license when my major competitors have not taken a license.
Right,
It
Scott's
makes
point,
me
yeah.
uncompetitive.
Yeah, right, yeah.
You know, and that's the world we live in. When we allow the giants not to have to take licenses, how could we expect anybody who's not a giant to take a license? I mean,
Yeah,
but-
it's also a race to the bottom, of course. right.
you know, there's so many, and this is by design. It has to be by design. You know, you couldn't be better at pushing prices down, and you couldn't be better at stringing people out unless this was intentional from the outset. But Ted,
Yeah, I have a question, a comment. The first question I have, I know how to solve this in 30 seconds. And Etsy actually had it solved years ago by mandatory mediation if the two parties couldn't agree, the implementer and the patent holder. IEEE has tried this. I understand that failed as well. So this is not a system that developed in fog or in darkness, something. You know, companies chose to have it this chaotic and this bad. And the question, to my mind, and I wish I could say this in Latin, but who is benefiting? Why do we want it this badly screwed up? That'd be the first question. The other one, Scott, you mentioned the price is falling in that. I was at a function at GW, your own school, and they had, I think it was treasurer of the FTC there, and she explained, I want to explain this to you because I know you're slow sometimes, but she explained that even though what you
Thanks for
say is
that,
true, that if this was in fact hold up and so forth, that the prices could have been dropping even lower, we don't know. So you can never prove your point, and that was her point, is that whatever anyone says on the other side, they can't prove it, and she's sticking to her guns. But the question is, who is benefiting from this? Because it's obviously a conscious decision. Etsy could go back to mediation as a heartbeat, and these standards-based organizations go back to some sort of compelled process in a heartbeat. They don't. They vote it down, parties. And it's question of just the very large companies like Apple, I understand, don't like to do it because they say, we're not ever going to pay you, so we get 10 years in that, and then we get the same rate anyway, so we have no incentive to ever pay anybody. Which, another point, the organizations could write in their organization penalties for not negotiating good faith in that. They don't do that either. So there's a reason this is happening. And I don't know exactly what it is. Perhaps you all would have much more insight as to what that is.
Yeah, okay. You want me to start on that one? There's a lot to unpack there. So, Ted, a great question. The first thing I would comment on is the mediation arbitration issue. So I joined in a private conference at a place called Bretton Woods a few years ago in the winter. Bretton Woods is where the accords that led to the International Monetary Fund were entered, after World War I or something like that. World War II. It's a famous, kind of a resort in the White Mountains in New Hampshire, pretty remote. And we spent a couple days discussing with implementers and innovators in the room, SEP issues, these kinds of issues. And we discussed mediation and arbitration. What I came away with was that both the innovators and the implementers were okay with mediation because there's no court-mandated outcome. And if what you're trying to do is talk, and run the clock for 5, 10, 15 years, mediation's fine because you can run the clock with mediation. When you got all the money in the world, a few $1 million for mediation, it's chump change. So mediation wasn't the issue, really, as between the implementers and the innovators. The issue was arbitration. Because when you get to arbitration, then there's going to be an outcome. And that was where The innovators were very quick to say, we are all in for arbitration. We are happy to put our disputes in front of an arbitrator, and we are happy to accept the outcome. The implementers, no way. And that was where the discussion broke down. And they had any number of reasons why they didn't want to arbitrate. The arbitrators don't understand. They're not able to really get into the nuances of the issues. It's somewhat arbitrary. It splits the baby, et cetera, et cetera. But what it came down to is fine mediation, no arbitration. The other, Ted, to come to the sort of the nub of your point, are we tolerating such a broken system? Well, to kind of sum up what I think all three of us have been saying, we're here because parties that are extremely well resourced on the implementer side like a system in which they can litigate for a long period of time and pay no more at the end of the litigation than they would have paid at worst under a reasonable royalty at the beginning. This is a topic that Jonathan Barnett and I wrote a paper on, what was it, about a year ago or so. And Jonathan so nicely put it in language similar to yours, Scott. I wonder if you can come back to this. It's like taking out an option on the part of the implementer. The option is the chance of invalidating the patent. The cost of the option is the litigation expense, but really no other expense. Because worst case, if you fail to invalidate the patent, you're going to get a license at the same rate you would have gotten it for in the first place, only several years later, in which case you get to take advantage of Gene's point about inflation and paying in lower value dollars.
Yeah, and just another, so Ann Lane Farrar, who's an economist, and I have a paper where we talk about these missing options in this analysis. But our basic take is, like, the world's complicated and future is uncertain. So we all know this. If you actually pay to explore, run the clock, test, fail, test, succeed, opt in, opt out, if you pay for all of that, you ought to get some benefit. And if you don't pay for all of that, you ought not get that same benefit. So any system that is not pricing that big set of options in that big gray middle where all of life is lived is a system that is really missing the ball of wax.
Yeah.
And it's our job as professionals on either side to be injecting that reality. That, again, this is Nobel Prize winning stuff. This is not subject to significant dispute anymore. This is beyond all reasonable doubt. It would fail Dalbert et al. To not take evidence on these ideas if presented. So as professionals, we can do our best to inject that information set, these lost options, into the analysis.
Yeah. Okay. Is there another question? We can take another question we have. I know we're going to go just a little bit late here, but we don't always get three honorable panelists. So one more question and then we'll wrap up. Oh.
Here's one.
Oh, go ahead. Now, I'm sorry. It should.
Yeah, so first off, my thanks. This has been a great panel with lots of great thoughts. It's going to take me time to sort of think through this and digest. But one thing that comes to mind is that, you know, we supply companies, some of which are smaller, primarily in Europe. And you know, I've heard earlier, you know, the economics that both sides should negotiate. And David, you mentioned of how, you know, implementers may not want arbitration, they want mediation, whatever it is. A lot of my customers, they say, you know, we don't have a legal department. Who tells us what the right price is? And we're ready to pay, but who's going to tell us what the right price is? Now, Europe has this idea that there'll be an expert. If you want, you can ask them to tell you what the price is, and if you're a small company, you don't have to pay. But if we don't have that, who's going to be a reliable source for a small company that hopes to be big, is ready to take a license, but as Gene mentioned, they can't take a license at a rate that's higher than a big competitor is going to take, or they're going to be squeezed out of the market?
Again, I'm happy to start.
Sure.
So the answer to that is, if you're in the automotive industry, it's easy. Avanti's got a now well-publicized rates that are highly standard, easy to find, and require no price negotiation. It's like walking into a grocery store. You want Campbell's soup? Here's the price. It's very easy. Similarly, at least some, I don't know about all of them, but at least some of the major licensors individually themselves publish their royalty rates, their licensing rates openly. So you can just go on the internet. Again, it's like walking into a grocery store. It's not ambiguous. And then the third thing I'd recommend for small companies is to have an honest negotiation and discussion about that. Under NDA, the licensors, this is to Scott's point before, these agreements could be complicated. Modulo what you're negotiating for other terms and conditions, the length of the license, the indemnities, the duration of the royalties, the terms around termination of the agreement, whether it's got futures built into it or it's a guillotine. I mean, there's a whole bunch of parameters. Modulo standardization of those, my experience is you can have under NDA an honest negotiation, an honest discussion, it's really not a negotiation, that part of it, with the licensor about what they're charging, what their average royalty rates are, what their royalty rates are for companies your size and the similar conditions to yours. And you can get an MFN in your agreement, at least as to the royalty provision, that ensures that you're being treated equally and consistently with others.
And then the only just thing to build on all of this discussion is that whether it's a small entity in a one-off interaction or multiple small entities or a big entity, if you look, for example, at the tribunals in Europe and the tribunals in the US that have been more in the middle on this debate, it is not an accident that those are the less dynamically kind of politically valent parts of those governments. And if you look at the parts of the governments that, the ones that are more in the middle are more removed from politics. They're not apolitical. We all come out of politics, our governments. But let me be specific. The European Court of Justice is very different than DG Competition. The US ITC is very different than the US FTC. It's not that somehow the wizards in one of those shops wears a good hat and the wizards in the other wears a bad hat. That's not what explains the difference. What explains the difference is the internal power dynamics within different organs of government. When you have an organ of government where people inside the power system are of different political stripes and they're evenly matched, they are compelled through their own selfishness to do the horrible thing that Gene asked all of us to do, which is talk and listen collaboratively around ideas. Because if we don't, it gets toxic quickly, and we all pay the price powerfully.
Yeah, and the price is huge.
Yeah.
The price is huge.
But in systems of government where one side has a lot of power for a little while, wahoo! It can get even worse.
Yep.
So the balanced systems balance themselves out more. They're not perfect. They're not awesome. They're just less pernicious than the imbalanced systems. Please.
And imbalance is what we have now, in my view, and the cost to the technological advance and prominence of our country is enormous, because huge parts of innovation come from smaller players. Not all of it, but a huge part of it. So if you want to have a system like we have now perpetuate itself, you're going to lose more and more of the mid-size and smaller inventive entities, the R&D shops, engineering firms, hospitals, universities, many other smaller players. And the giants will thrive, but the total innovation will be far less than what we've had in the past and what we need for the future of the country. So that's the stake, and it should be obvious what the right direction of reform would be.
Yeah. Okay, guys, we're probably going to need to leave it there. What I'll just say quickly, in this panel, I took the position of the innovators quite heavily, and that's where, for the most part, my beliefs lie with. What I will say is we're going to try and even this out, because the one question that we didn't touch that we will really queue up for tomorrow is it a FRAND offer to start with? Because that really is where all this starts getting out of control. And we assume, by and large, for this panel, that it has been a FRAND offer, and now we're not getting, we're not moving forward. And when you're talking about a lot of these myths, and the people who say that, it's easy to come to that conclusion because they don't seem, in my view of the world, to ever have seen a FRAND offer. And they have to have seen a FRAND offer at least once, right? You know, and that's where I think some of the frustration is. But on the other side too, Avanci was mentioned here. You know, I reached out, I invited multiple people to speak from Avanci. I was told that they are not involved with SCPs. That's what I was told, which is obviously not true. And you know, and I think that, you know, so my radar goes up when I hear people say, you know, like, you innovators, just innovate. You innovate because you innovate. You don't need to get paid to innovate. It's like, that my spidey senses are tingling. When I hear somebody who clearly has enormous portfolios of SCPs say, "Oh, we don't deal with SCPs. We're a patent pool." Like, okay. And that's why I really encourage, and I'm glad, Scott, you brought that up at the end. We need to have an open conversation and get past, hopefully, all the posturing. There needs to be certain posturing, right? That's negotiating. That's litigating. But at the end of the day, this is going to be Pollyannish, I hope we can start to live in a world where both sides really want to come to a resolution, and we don't need to bother people like Judge Michelle to make a decision. We can do it ourselves. But thank you very much, guys. I really appreciate it.
Thank you.